everyone. Welcome to LexTalk, World Talk Show presented by Clickaway Creators. Today, we have Gergina Kyoseva with us. Gergina is an attorney at law registered with Sofia Bar Association with the experience of more than 10 years. She is specialized in corporate and commercial law, including insolvency and restructuring, dispute resolution, and tax. Gergina advises on M&A deal structuring, corporate and tax aspects of cross-border transactions, and corporate swap, share and asset transfer, liquidation of legal entities as well. Gergina is currently holding the position of head of legal of Bulsatcom, EOOD, Bulgaria, which is like the biggest pay TV operator. Prior to being engaged with this organization, she was working for 6 years as an associate lawyer at Wolf Theiss, one of the leading law firms in the Central, Eastern, and Southeastern Europe, where she kind of also advised and represented creditors in some of the major insolvency proceedings in Bulgaria. Yes, absolutely. I get it. I've been saying a lot about her, but without any further ado, let me just quickly introduce you to the woman herself. Hello, Gergina. How are you?
Hello, Harti. I'm fine, thank you. Thank you and LexTalk for giving me this amazing opportunity to present myself and the work that I'm doing. It is a real pleasure talking to you today.
It is a pleasure for us, trust me. We're really excited to know about your journey as a legal professional. So please throw light on that first.
As you correctly mentioned in my introduction, I've been practicing law since 2009 as a registered lawyer, and I graduated from Sofia University in 2007. I've been working as a lawyer many years, first for some international law offices, after that as independent practitioner, and now as I'm heading the legal team of Bulsatcom EOOD.
Thank you for sharing your journey so far, Gergina. Now, I'm sure that this is a very unfair question, and I get this a lot from other people as well. But it's kind of really exciting to know the issues, the cases that you guys have worked on. So if you'll be kind enough to tell us any complex issue that you have worked on so far. Also, if you would like to describe the complexity of the matter.
Thank you for this question. In the last few years, I've been working on the financial and operational restructuring of Bulsatcom EOOD, which is the Bulgarian largest pay TV operator, and they provide some services, IPTV, satellite TV, and TV everywhere services. In the beginning, I joined the project as an independent legal advisor, while at the later stage, I was invited to head the legal team. I would say that this project is complex on many levels. To give you a bit of a background, you may probably know that an increasingly popular tool for companies seeking to restructure in the US is a procedure known as Chapter 11. In the European Union, similar procedure has been introduced with the Directive on Insolvency, Restructuring, and Second Chance. And so far it has been implemented in several member states. Such procedure has been found effective because it allows for the management to remain in control of the company and develop a restructuring plan under the protection of automatic stay. Since 2017, Bulgaria has introduced similar procedure, However, such procedure has not been found effective by the business, and is very rarely used in practice. What we did, and I would say that this was a precedent on the market, was to implement in practice for this particular project an out-of-court stabilization procedure. Back in the time, the company had accumulated significant debt towards its lenders, bank and international financial institutions, also to the National Revenue Agency and commercial creditors. And as part of the restructuring, all company debt was renegotiated, and settlement was reached simultaneously with all the major creditors of the company. The financial creditors and also the commercial creditors. The public debt was paid. All enforcement proceedings were terminated. And settlement was also reached with one of the existing shareholders in the company and all his related companies. In exchange for the debt reduction, the financial creditors acquired shareholding participation and provided additional financing. Thus, actually, Bulsatcom managed to overcome the financial difficulties without following the lengthy and formal court stabilization procedure, which is prescribed by the Bulgarian Commercial Code. After the financial restructuring, I took the position as head of the legal department. And we, together with the management team, continued with the operational transformation, where new products and services were implemented, internal processes were improved, and client base has also been stabilized. I would say that this is the most interesting and complicated project I worked so far. And I would like to finish the answer to your question with one of my favorite quotes of the entrepreneur Jim Rohn, which says that if you are not willing to risk the usual, you will have to settle for the ordinary. And I may say that in my professional life, I do not like to settle for the ordinary.
Thank you so much for throwing light on the complex matter. Indeed, it was a really complex matter. Now, with that being said, Gergina, pandemic has seen a lot of changes in all the industries, including the legal industry. Now you have seen that there are a lot of remote proceedings that are going on. Technology has kind of taken over everything in a positive way, of course. Do you think that this is like a sustainable and like a possible way to increase access to justice?
Remote proceedings were introduced in the Bulgarian legislation in 2020 with amendments in the Civil Procedure Code. In civil and commercial cases, each party may participate in the hearing through a video conference when such party cannot appear in person in court. Collection of evidence, such as witness statements and expert opinions, can also be conducted remotely. Although remote proceedings have been explicitly introduced in the legislation, such option is currently very rarely used in practice. Usually such possibility is used by regional courts in some small towns. However, in criminal cases, remote proceedings are generally very limited. Such possibility exists only in some specific cases. For example, questioning through video conference is allowed for witnesses and experts, But with regards to accused, in the pre-litigation phase, the accused cannot be questioned remotely when the court decides on the detention measures. And it is generally not allowed also for questioning of the accused in the litigation phase, subject to some minor exceptions. I think remote proceedings could be sustainable and a possible way to increase access to justice only if those are implemented carefully in order to avoid the risk of impacting the fairness of justice, because this is the biggest risk here. There is no one-sized approach and should not be one-sized approach to all proceedings, because courts hear a broad range of cases, both civil, commercial, criminal, and all these cases, they pose different challenges and they have different benefits. All relevant factors should be taken into account, such as the complexity of the case, the fact-finding, the document collection. By way of an example, remote proceedings might not be the best option for a case which is expected to involve exchange of significant amount of documents. So yes, this could be a good way to increase access to justice and a sustainable way, but should be carefully implemented and by taking into account all relevant factors.
Thank you very much for sharing insight on this and sharing your views on this. Now, in this era of legal technology, if you can please quickly tell us that what are the mostly common used tools for you?
Given the vast number of documents and information a lawyer works on a daily basis, it is, to my mind, very important for every lawyer. It is also very important for me to have a good document management and document storage system. Another very important tool is a good legal information system, which may facilitate access to legal sources such as case law and regulations. I would say that it is essential for my work to have a system which has a good case law search engine. Also, in such pandemic times, a third most common tool that I use is a video conferencing and collaboration service tool. I use those tools on a daily basis because it really facilitates meetings and communication. So yes, I think these are the most important tools for me.
Thank you, Gergina. Now, when we're talking about technology, and we all know that it's quite time-saving, but when we talk about time, it's money in any profession, and legal, it's like most of all. So how do you ensure that you make the best of your time as a lawyer? What do you do differently?
As you said, yes, time is money, and in legal profession as well as business consulting in general, the product you are selling is actually your time, knowledge, and expertise. With this regard, it is extremely important how you manage your time, because in the end, it is your time that you put in the invoice to the client, and the client should be contented from the correlation between the quality of the service and its price. To make the best of my time, on the first place, I'm trying to plan ahead to the extent this is possible. However, I'm more fan of a short-term planning and time management. I do not make plans for more than a week ahead. As in this dynamic working environment I'm currently placed in, it will be ineffective to make plans for quite a long time. Secondly, I'm trying to prioritize wisely. by taking into account the urgency and the priority, the importance of each task. Needless to say, core deadlines are always on my top priority list, because you might probably know that a missed core deadline is not covered by any professional insurance. Another thing that I'm doing is I'm trying to delegate where possible. Here is the place to say that in our profession it is of particular importance to have a strong team, a strong support team, and a team which can work independently with minimum guidance. I'm glad that currently I have such a team. So in summary, yes, prioritization, planning, and delegation are the tools that I'm using to make the best of my time.
Thank you so much, Gergina, for answering that question. Unfortunately, we are coming to end of this amazing conversation. But before I let you go, I really want you to throw light on any of the challenges that you might have faced, because you're the head of the entire legal department of a big company. So how and what kind of the biggest challenge that you faced and your learnings out of it? Any tips?
Thank you. It's a very good question. The biggest challenge I am facing is how to effectively cover and meet all the legal needs of the company of such size and all company departments. With minimum legal resources. The legal function, as you know, is a support function. Our main focus is to meet the expectations of other departments, both in terms of timing and in terms of quality. We have cases in many different areas of law. Our work is so diverse that we can do employment matters in the morning and competition in the afternoon. On the other hand, a company in the process of restructuring is cost sensitive. So it was a challenge to structure the team and our work in such a way to be able to cover all these areas of law and to find professionals with diverse competence in such different areas of law.
Thank you very much for sharing such great insights with us throughout the interview. And of course, I'm very sure that our viewers will get to learn something or the other from your experience and expertise. Thank you. It was a pleasure having you, Gergina. And for our viewers at the same time, please like and share this video. And do not forget to subscribe to ClickAway Creators YouTube channel as well to appreciate what we do. And you have more coming from the legal leaders like Gergina herself. This is Bharti for LexTalk signing off.